Hi, welcome. Could you please state your name and profession?
Hi, my name is Katarzyna Czapracka. I'm a partner at White & Case, and I'm dealing with competition law.
And why did you specialize in competition law?
Well, it is probably the most interesting and complex area of law, and one that is least, I'd say, legalistic, because you really have to understand the markets, and there's many sort of cross-border aspects, at least in competition law that I practice. So it is a beautiful combination of law, public relations, international relations, and economics, importantly. And so I find it extremely fascinating and fulfilling to be able to work with questions like that and deal with that in my professional life.
Great. The new Vertical Agreements Block Exemption Regulation entered into force on the 1st of June. What is the one change that you find particularly significant for digital markets, and why?
I think it's the recognition that offline distribution may need to be protected. That general principle leads to some key changes in the approach taken by the Commission. One relates to dual pricing. You can differentiate between online and offline pricing to your distributors. Another one is the recognition of the fact that you can have different requirements depending on whether distributor acts online or offline, and the general recognition that online sales can be regulated, and that you can impose on your distributors selling online certain conditions relating to how they sell, how they deliver, and regulate how they advertise online as well.
Thanks so much. And the new regulation and the guidelines aim to afford legal certainty to businesses. Do they succeed in your view?
Well, they certainly make a step in the right direction, but there's many open questions. And I think as it is the case with many documents that the European Commission publishes, it's good for the business. You have a lot of interesting new questions that you can answer and help your clients. So this is really exciting.
My last question is, with one word only, how would you describe the biggest challenge that digital markets pose for competition law?
Well, my word is labels. And I think that nowadays, the pendulum has swung in the direction that everything digital is bad or wrong or potentially suspect. And there are many new labels that are created, maybe not so much in the distribution area, but the DMA creates some labels and buckets like self-preferencing or anything data related. That's, what you do, interoperability. If you prevent that, that's potentially a problem without really looking into facts, the business models and questions and so on. So there's this form-based approach that I think is now prevailing, because there is this idea that you have to act fast because the markets are moving fast and you have to intervene and adopt decisions. I think that's a challenge. And I think it's a challenge for regulators because they can get things wrong. And it's a challenge for the digital players because it imposes a significant constraint in terms of how they can deal with their business, and a challenge for them to respond to the changing regulatory environment.
Thanks so much, Kasia. Have a good afternoon.
Thank you so much as well. It's a pleasure.